All right, good morning. Welcome to chapel. Let's go ahead and come in and get started. We're excited today to have a guest speaker and a special topic. Our speaker is Luke Snodgrass, who is son of our Rosemary Snodgrass and Don Snodgrass. And he is a recent graduate of Samford Law School, whatever the law school is called there. And so he has a JD. He's practicing law here in Florence. He has also worked as a counselor before that. And so he has a lot of experience that's going to help us this morning. And the topic has to do with churches and legal issues. And I'll say I suggested this topic because I had seen some news stories about churches that were getting in trouble with the way they were counseling their members in certain areas, particularly, and I guess Luke might take it in this direction, but I'll present it this way in any case, that there were some times when within a church, there are times when there is, we might say, a perpetrator of crime against another member, and there is an attempt to handle that internally within the church. I'm talking about some sort of abuse that has taken place. And from a ministerial perspective, there's the attempt to handle that internally, that, well, we need to bring this person to repentance, and then this other person that is the victim of their crime needs to then forgive them, and there is the attempt to perhaps even shame the victim into forgiving, and there are legal issues and ramifications with all of this and how we go about doing this, and churches have been brought to court for these sorts of things. So we need to be aware of what we're getting ourselves into, especially when a crime is involved, and how we need to handle that. So Luke is going to help us think through all sorts of issues when it comes to the church and the law. So thank you for being here, Luke. Hand it over to you.
Morning, everybody. I'm Luke Snodgrass, as Ed said, and I thank you for that introduction. Before we get into the meat of everything that I wanted to talk to you about, I'm going to relay a short story. Santa Claus, the Tooth Fairy, an honest lawyer, and a preacher were all walking down the sidewalk together when a $100 bill was spotted on the ground. A scramble for the money went by, and who came up with the money in the end? Obviously the preacher, because the other three are mythical beings. I tell that story, I tell that joke, because it's important for us to understand the roles that everybody plays in any given situation. Who you are, what role you're filling, and how that impacts your relationship to the situation. So the first question is, when you are engaging in ministerial counseling, when you're engaging in ministerial care, who are you at any particular time? At any time, you can be the minister, you can be the preacher, you can be, as the legal world refers to it, the clergyman. And we'll talk about what that means here in just a little bit. You can be a counselor. Now, understanding for that full title to apply to you, you would need to be a licensed provider in the state where you're working, but that is possible for you to be considered a counselor. Or are you a friend? Just somebody that a person that you know is relying on, is confiding in, is talking to. And how you are can be, or who you are rather, can be interpreted by a lot of different things. The location that you're in, the relationship that you have with the individual, whether the conversation is being maintained in confidentiality. Are you being paid? All of these things will dictate who you are to that person. A conversation being held in your office might be looked at differently from a legal standpoint than that same conversation being held at your home or the home of somebody else. Because at that point in time, depending on where you are, determines the legal role that you're playing at that time. Now, I've got some good news for everybody. Malpractice. The word that makes professionals like doctors and therapists and lawyers even cringe in fear. Congratulations. Ministers have been decided by case law that there is no such thing as ministerial malpractice. Yes. In Alabama in 1987, the Henley versus Richards was the Supreme Court of Alabama case that came out and stated in Alabama there is no such thing as ministerial malpractice. The reason being, there is not a professional code of conduct for ministers. Alabama doesn't recognize it. In various cases, they basically said that while there is a code of ethics and morals for ministers to adhere to, it's not something for the state to get involved in. That it's a spiritual matter, and because of that, ministers are more or less exempt from any sort of malpractice action. Other states could impose a duty, could impose this standard of care that a minister is supposed to abide by. None have yet. But because this is case law, because this is how a judge has interpreted a situation, it's open to being changed. There could be a statute that comes down that lays out a grounds for ministerial malpractice. Nothing has happened yet. And I would encourage everybody here to make sure that you aren't the cause of the case law to change. So to that effect, we're going to be discussing ways that you can ensure that you adhere to the law, adhere to what's expected of you, and make sure that you aren't the example of ministerial malpractice. Now, the first thing that we're going to talk about is this concept of privilege. What is privilege? In the legal world, there are different types of privilege. There is situational privileges where, given the nature of the communication that I am engaging in with you, it's privileged. Meaning that it can't be discussed, it can't be divulged to anyone outside of that room. And especially not given as testimony in court. The best example of this is if I was a criminal defendant and I was engaging in a plea deal negotiation with the state's attorney. Anything that I say during that negotiation process is privileged information and can't be discussed in court. Alternatively, there are relational privileges that, based off of my relationship to you, the conversations that you and I have are protected. Most famous that everybody knows is attorney-client privilege. But there's also doctor-patient privilege, spousal communication privilege, marital communication privileges, and then what we'll be focusing on mostly is this penitent clergyman privilege, and then therapist-patient privilege. Now, as I said, each of these depends on my relationship to you and your relationship to me, and how at that particular point in time, understanding our role in the situation, understanding our role during that conversation, how that's going to impact what a court views, what a court is willing to hear based off of your role. So I'm going to encourage you guys to check your privilege. Very first thing that we're going to look at is communication with a clergyman. So, who's a clergyman? Well, Alabama Rules of Evidence number 505, which is specific to Alabama, but it's a copy of the federal rules. So this is really just kind of a broad, most states will adhere to the same rule. There could be some exceptions depending on which state you decide to start working in, start living in, but for general purposes, we'll just be looking at Alabama's rules. But Alabama 505 defines a clergyman as any practitioner of a bona fide established church or religious organization. So anybody that is working for the church, providing ministerial services for a established religion. So, notice they exclude cults. That's good. Is protected by this clergyman privilege. Now, what does that mean? The idea behind it is to protect the sanctity of confession. The time when I, as a as a member of your congregation, as a penitent, the legal term, comes to you seeking to confess, seeking ministerial guidance, seeking spiritual advice. Now, initially it was strictly that, strictly confession. My time in the booth with the priest where I was confessing my sins, that was what was originally protected under Old English law, which we adopted in the United States and have carried on. Now, the courts have taken a much broader view. They've begun to look at it as any time that I, as a member of a congregation, am coming to you as a minister seeking guidance of a spiritual nature, that's protected. My conversation to you is privileged. And because of that, the court is going to not allow testimony by you of what I've said. Now, a unique aspect of this is the idea of whose privilege is it. Most privileges are invoked by me, by the person being accused of the crime. And I invoke my attorney privilege, I invoke my marital communication privilege, I invoke my clergyman privilege. I say, Judge, I was talking to him as a penitent, and he is my clergyman, he is my minister. You shouldn't allow this. Well, that is one way that this clergyman privilege can be applied. Uniquely, the clergyman, the minister, the preacher can also apply this privilege. He can request, Judge, I was acting as this guy's spiritual advisor. I don't want to testify against him. That's there. That's something that you as a minister have the right to invoke. Now, moving on. We come up with this idea of the psychotherapist-patient privilege. And why do I bring this up? Because a lot of what we're looking at, a lot of what we're talking about is things that get divulged in ministerial counseling situations. Times when you are acting as something more than just a spiritual advisor, but almost a mental health professional light. And I bring that up because if you look under 503 subsection A, we can read that any reasonable person who believes that the person that they are engaging with is a licensed practitioner in the state is subject to this same privilege. And that's why I bring up why it's so important to define your role, to define your relationship at any point in time. We discussed this idea of a reasonably prudent person in the legal world. It is the ultimate average Joe. He is of average intelligence, he is of average learning, he is of average everything. At that point in time, if the judge deems that the average person in that situation as described to him would assume that you are a licensed practitioner in the state in which you're working, then that's a second level of privilege. It's another way that somebody can exercise that privilege. Now, the things that I discussed earlier about receiving payment, that would be a red flag. If I was being paid by a person individually to provide counseling services, that would be a strong indicator that you are representing yourself as a licensed practitioner in the state, right? Things to understand whenever you're engaging in this kind of counseling ministerial role. Again, we talk about who's a patient. Anybody that comes to a psychotherapist or counselor is considered a patient. Confidentiality is important, both in both levels of privilege, both for the ministerial and for the psychotherapist. People assume that your discussions with a therapist are confidential, right? Anytime that you go to a counselor, anytime that you go to a therapist or whatnot, you assume that the conversation you are going to be having is private. What about with a preacher? What about with a minister? You assume that, when I go inside my preacher's door, we close the door, we start talking, we assume that that's going to be confidential, going to be private. Now, what does that mean? Does it have to be private? If there was somebody standing at the door listening, to what I'm saying as I'm confessing my crimes to my minister, does that void this privilege? No. We again talk about that reasonably prudent person. If that reasonable person assumes that the conversation that you and I are having is going to be a private, confidential, kept between you and I, then the privilege is put in place. Whether it is actually confidential, whether it's actually private or not. There could be somebody standing in the closet listening to everything that we say, but as long as I don't know that they're there and I have reason to believe that everything that we're saying is confidential, then it is privileged. It is, kept between you and I. Now this, whose privilege is the psychotherapist patient privilege? This is primarily for the patient to invoke. The therapist can invoke it for the patient, but that's generally more of a situation where the patient is deemed incompetent for some reason, and can't make that kind of decision for themselves. But this is generally, something that the patient themselves would have to say, hey, this is privileged communication. I don't want you divulging this. Which brings us to a kind of a nuanced concept: privilege versus confidentiality. Confidentiality and privilege overlap in many situations, but they're not the same. Privileged communication is what? It's what I'm saying to you. It's what I am communicating to you, my statements, your observations, and it deals specifically with your testimony against me. Confidentiality applies to written records. Sometimes it's going to be what I've said to you. You're going to write that down as a therapist, potentially as a ministerial counselor. You're going to write down things that I say. Those records can be subpoenaed, and then the judge can request that you discuss your records with him. Obviously there's going to have to be a court order. There's going to have to be, reason to subpoena those records. But ultimately, those records can be divulged to the court. And there are levels of privilege: absolute, diluted, and qualified. Basically, those are really, technical terms about how privileges get interpreted. And as far as what we need to be concerned about is that your clergyman, your ministerial privilege is an absolute privilege. No judge is ever going to say that you have to come in and divulge what was said to you under the sanctity of your role as a minister, except in Missouri. Missouri's kind of weird. They do their own thing, and they basically have said that if enough testimony comes out in the course of a trial that says we have to know what was said to this minister, that can be divulged. But generally speaking, ministerial privilege is absolute. So why is this important? We need to understand and we need to clearly define our roles, how we are interacting with the people that you guys are ministering to, counseling with, working with, because, as we've just shown, how you define yourself, how you show yourself, how you present yourself to those people around you dictates how you are responsible for the information that you glean and how the court is going to look at anything that you glean. Which brings us to our next big topic, is this idea of a mandated reporter. Now, what is a mandated reporter? It's somebody who the law has decided has enough contact with potentially vulnerable people that, based off of that relationship, based off of that closeness, that connection, they are required to inform the proper authorities, to inform law enforcement, DHR, somebody that can handle the situation whenever they assume or whenever they have a reasonable belief that abuse is occurring. In Alabama, Section 2614-3A specifically highlights, right beside each other, mental health professionals and members of the clergy as defined by Rule 505 of the Alabama Rules of Evidence, which we just went over. You guys, working as a minister, are going to fall under one of those two categories. Whether your members perceive you as a counselor or not, you're either going to be a minister, you're going to be a clergyman under 505, or you're going to be that perceived mental health professional. And because of that, congratulations, you're a mandated reporter. That means that because of that situation, because of that relationship, you're required to go and tell somebody, law enforcement, DHR, some sort of state agency that can intervene for the child or other abused person. Now, I say other abused person, that is a person that cannot take care of themselves. Generally, what the state looks at is children, incompetent people with mental defects that can't take care of themselves on a regular basis, the elderly. That's who mandated reporters are designed to protect. For some reason, the state, in their decision-making power, has excluded spousal abuse from this mandate of reporting. I would recommend that you err on the side of caution with that, as opposed to just say, "Oh well, I'm covered." They didn't say that I have to report this. But we'll get to that in just a little bit. Now, weirdly enough, there's an exception to mandated reporting. Alabama section 2614.3, subsection F, that same one that we just talked about, says that clergy, again defined by 505, shall not be required to report information that is gained solely in the confidential communication privilege pursuant to the Alabama Rule of Evidence 505. So what does that mean? As a minister, are you required to report abuse? Legally, it depends. How did you come by this information? Again, defining your role in any given situation. If somebody is coming to you as a minister specifically seeking spiritual guidance, under Alabama 2614.3, subsection F, you are not required to provide that information. The law does not hold you to any sort of special standard at that point. If in a particular situation somebody comes to you as a friend and says, "Hey, this is going on in my life," as opposed to your role as a minister, and good luck delineating what role you're occupying at any given time. But that's why I encourage you to make sure that you understand who you are in any given situation. Well, that comes outside of that exception, that 505 privilege that we talked about. And ultimately, even if it is brought to your attention under that 505 exception, you're not required. Required is a loaded word in that sentence. The court's not going to say, "Oh, you didn't come to us and tell us what was going on," ministerial malpractice that we talked about. The court's not going to say, "You failed as a mandated reporter. You didn't step in when you should have." That's not going to be required of you. But it's your choice. It's your option. Now, we get into this idea about reporting. What is reporting? Who do you need to report to? Well, as I discussed, state agencies, the police, DHR, somebody that can step in and actually do something to stop the situation. What are you reporting? You're reporting suspected abuse. Do you need evidence? Not really. You just need to have a reasonable suspicion. Again, we talk about that reasonably prudent person, that idea of this average person in this situation with the information that you have. Would they reasonably believe that there is abuse, potential abuse going on? And then when? Immediately. You don't sit on this and wait. You don't sit and say, "Oh well, we'll see how this is going. And we'll check back in a few months, and maybe this will all have blown over." That's not what's required of a mandated reporter. It's immediately when they become aware of the situation, they are required to go to the authorities. So after you report, then what? What's happened to the relationship that you have with whoever you reported on? It's going to be impacted. I'm not going to lie. That's going to change how you are related to by the person that you're reporting. Are you going to be required to testify in court? Potentially. But as I outlined, the idea of privilege will generally protect you. If the person that you reported on has an attorney that represents them, more than likely they're going to say this is privileged communication. The minister can't testify, and then also you still have that opportunity to say this is privileged communication. I don't want to testify. But ultimately, you're going to be able to decide whether or not you are going to be required to testify. Your records might be subpoenaed. You might have to turn that over. Always keep that in mind whenever you're documenting any sort of ministerial counseling that you engage in. But at the end of the day, I think that the ultimate concern for anybody, for anyone that engages in ministry and counseling and caring for others, is we've got to make sure that we protect those people that can't protect themselves. We have to look after the defenseless people, and we have to make sure that the proper authorities, the proper channels are followed. And whether that privileged communication comes into play or not, that's overcome by that mandate of reporting. And again, while you might not be required by law to do so, I would argue that you are required by ethics to do so. So I know that this is kind of a heavy topic. If y'all have any other questions or anything else that you would like to discuss, I'd be more than happy to talk with y'all here in just a little bit. But that ends what I have to share with you all today. I hope that I've at least shed some light onto your role as ministers and how the law looks at ministry and ministerial counseling in general. Thank y'all.